Nature. Don't you just love nature? You know, I'm feeling really good today. You want to know why I'm feeling really good? Because I met this deed, and he seemed really awesome. So, you know, I mean, I'm a little bit worried that he might not be valid. You know, but if he turns out to not be valid, I mean, maybe he could go to deed therapy or something. I've just never met anybody like this deed before. And you know, so I'm gonna go through my checklist with you because you and me, we're confidants, right? Yeah, I know we've bonded. We're bonding. I'm bonded. Hi, bond. Okay, so let's go through it because, you know, there's, oh goodness, 1, 2, 3, 4, 5, 6, 7, 8, 8 things that we need to check off anytime we meet a deed, right? Ladies, gentlemen, anytime we meet a deed, we need to check these 8 things, make sure it's all on the up and up because we don't want to get involved in a long-term relationship with a deed that is not valid. Now, those relationships just never work out, now do they? Let's start. Okay, so let me think of my deed. I'm imagining him. Oh, it's beautiful. Just so beautiful. Written. Written instrument. That's the first thing. I mean, the statute of frauds requires that all transfers in property must be in writing, and it requires all deeds to be written. Now, my deed, he's written. He's got all those, like, letters on paper. So now if he wasn't written, he would not be valid, and right, I'd have to move on to find another deed. Competent grantor. No, that's a lot of words. Okay, so the person granting the property is going to be your grantor, and they need to be competent. Okay, now competent has a lot of meanings. Now I've met some deeds that weren't competent. Okay, so it has to be signed by a competent grantor. Now, what does that mean? Now, if the person who is the grantor is not 18 years old, they cannot do this. They are not competent. They are considered a minor. So, under the eyes of the law, they're not competent. They're not mature enough to actually have signed something. Now, those would be voidable if the deed was a minor. They could go ahead and do it, and you would have the option, the minor actually would have the option of saying, you know what, I didn't know what I was getting into. Anybody who's mentally incompetent, and that's somebody declared mentally incompetent by the court, you know, even though I felt like my ex-husband was incompetent, he was not legally incompetent or declared by the court to be so. So I had to accept that as a reality, that it wasn't legally incompetent. But, okay, so I believe that the person, the grantor, who signed my precious deed was over the age of 18, wasn't mentally incompetent as declared by court of law. If so, that would have been void, somebody who's mentally incompetent. Somebody who would be drunk or high or something like that. I mean, those are all questions that would have to be answered. But so far, my deed checks out. Number 3. Identity of the grantee. Now that's me. I'm the grantee. I'm the one in receipt of this deed. It has to properly identify me. It has to say who I am. There can't be any question. It can't be like to that lady I met down the street. Can't be like that. It has to say somebody's name. It has to be specifically identifiable human being. Okay, so far my deed has that. If that weren't true, then that would just be void. If you can't properly identify the person you're giving the property to, not going to work. Words of conveyance. Now, my deed needs to contain words that say the grantor intends to transfer the title over to the grantee. Now, when I looked at all those words on the paper of my deed, it seemed like he had all those good things. He was saying the intent to transfer. Now, without that language, your deed is going to be ineffective and unenforceable. Okay? Now, those are things you don't want to tell your deed date, right? Hi, thank you for whining and dining me, but I find you to be ineffective and unenforceable. Those are strong words. Description of property. Does the deed contain a legal description of the property to be conveyed? Now, there are some acceptable descriptions. There are some aren't, like, all down yonder. That's not going to work. Okay, you need something that has to include a platted description, a government rectangular survey, meets and bounds. There's all different things that you probably learned in your previous real estate classes. It has to have that legal description. Otherwise, it's just not valid. It has to contain a recital of consideration. Okay, that means exchanging something of value in exchange for the deed. Okay, now in some states, now that's fine if you don't have the recital of consideration. It's just going to depend upon what state that you're in, but most deeds require this recital of consideration, and you will see that in there. A signature. Okay, now this is really kind of interesting because a lot of people think that, I'm the grantee, so my signature should be on it. But here's the thing, I don't have to sign it. The only people that have to sign it are the grantors. If there's only one grantor, fine. If the grantor is married, I hope my deed isn't married. If the grantor is married, then both husband and wife have to sign that because they're the ones giving something away. Okay? If it is not there, it is not going to be valid. Okay? And the last but not least, an acknowledgement of a witness to the deed. Okay? Now, some states determine if you don't have this, whether or not it's going to be valid. I mean, it varies by the states, but you really need to have somebody in there who might, witness that or notarize it. There has to be some kind of acknowledgement or witness depending on what state you're in and you meet those requirements. Whew. Well, I guess I've gone through all of these, and my deed seems to be of the valid sort. So I think we will continue our relationship. Have a good day, and I will see you next time.